Hello and welcome to the History of the Germans, episode 225, Der Ewige Landfrieden, or the Public Peace of 1495. Let me start today's episode with some outrageous national stereotypes. If an Englishman is disappointed with the way the affairs of state are conducted, he writes a letter to his Member of Parliament. A Frenchman in that same situation rents a tractor and dumps manure outside the Palais d'Elysée. But a German threatens to go to Karlsruhe to file a lawsuit with the constitutional court, the Bundesverfassungsgericht. Where did the Germans pick up this belief that the courts and the law will protect them against government overreach? Sure, 19th and early 20th century judges had, very much on occasion, stood up to the Kaiser's administration. And the Grundgesetz, the liberal constitution of 1949, had become a cornerstone of our national identity, following the comprehensive loss of moral standing. But there's also a very long strain that goes back to the Holy Roman Empire and the two imperial courts, the Reichskammergericht and the Reichshofrat. Both these courts have a bad reputation today, not in the least because Johan Wolfgang von Goethe saw it fit to ridicule his former place of work. However, not everyone shared his negative perspective. Many social groups, down to mere commoners, relied on these independent judges to protect their life and property against rapacious princes. What is also independent is the History of the Germans podcast. We owe no allegiance to lords, kings or emperors. We aren't caught in the clutches of devious advertisers and their insatiable enablers. We only report to you, the listeners, a luxury we enjoy thanks to the generosity of our patrons who've signed up on historyofthegermans.com/support, namely Mark K., Helen A., Alistair G., Martin S., Shannon S., Lair Caps, and Viking, who've already signed up. And please join them if you can. And with that, back to the show. I guess you're sitting in your car or on the train listening to this and thinking, how can there be a connection between what you've heard these last 224 episodes about the lawlessness and the chaos in the Holy Roman Empire and the high reputation court judgments enjoy in Germany today? I do admit, it's a bit of a long shot, but bear with me. So let's go back first to the early and high Middle Ages, the Ottonians, the Salians, and the early Hohenstaufen. The emperors of this period saw law and justice as their primary tasks, alongside the protection of the church and the defense of the honor of the empire. But what did they mean by law and justice? There were, of course, no codified laws in existence. The closest thing to a law code was the Sachsenspiegel and its variations. But this was a collection of legal customs compiled by a scholar, Eike von Repgow, not a compilation of binding laws. There were other competing sources of law: the ancient Frankish law codes, specific local traditions, canon law, aka the law of the church, precedents in the form of previous imperial judgments, and charters, some of them real, some of them fake. Roman law, specifically the Codex Juris of Justinian, was added to this melange in the mid-12th century when scholars in Bologna recovered the original text and Barbarossa reissued it as the Laws of Roncaglia. That was episode 55, if I'm not mistaken. There was obviously no coherence between these various sources of the law, not even a widely accepted hierarchy. Attempts were made both on the territorial and on the imperial level to reconcile all of these into one coherent law of the land. When it took until 1794 before Prussia passed the first comprehensive law code, the Preußische Allgemeine Landrecht, Austria followed in 1802, and then France with the much more modern Code Napoleon in 1804. And that Code Napoleon was then adopted by several German principalities. In other words, for 98% of the time the empire existed, there was no coherent law, not even on a territorial level. So, without a coherent set of laws, how did the courts arrive at their judgments, and why did so many people think these courts were placed to get actual justice? Now, if you read about legal disputes in the papers today, the headline is usually X won or Y had lost. framing the law courts as a place of epic battles where victory or defeat are determined by the rhetoric flourishes of the advocates and the stern application of the law. But most people who go to court, they don't give a jot about the law. They want something, and all other routes to compel the other side to concede have been exhausted. Going to court is expensive and the outcome uncertain, or as my law professors used to say, in court and on the high seas we are in the hand of the gods. Which is why about 70% of cases that go to court end in a settlement. If you take into account that most lawyers advise clients to settle out of court, the percentage of disputes resolved without an actual court decision may well be north of 90%. In other words, a legal system that promotes viable settlements gets you almost all the way to law and order. And that is what the imperial courts of the medieval emperors were aiming for: viable settlements. Only very rarely would they lay down the law. And where they did so, these judgments were underwritten not just by the king, but by all the powerful individuals who had been involved in finding the solution, committing them to uphold the judgment. The objective was not to discover the accurate legal solution, but to find a compromise that allowed both parties to leave the court with their honor intact. Disagreements could be framed as misunderstandings, and the abandoning of positions could be described as magnanimity. In the early Middle Ages, no other form of dispute resolution was actually possible. This was a society built on personal reputation. The political system consisted of personal bonds between vassals and lords, not institutions. A vassal followed a lord because the lord had promised to protect his rights and his status. And that expectation would be damaged irrevocably if the lord himself was subjected to a humiliating defeat in court. His followers would then wonder whether this lord was actually able to protect their land and their possessions, at which point the lord's only remaining option was to rebel against the bad king, which then resulted in civil war. That is what happened, for instance, way back in episode 3, when Otto, the definitely not yet great, convicted Duke Eberhard of Franconia to the humiliation of having to carry dogs. Subsequently, Eberhard rebelled, causing a civil war that nearly wiped out good old Otto. Bottom line, a medieval imperial court was a forum to negotiate a compromise, not a place to determine guilt or ascertain property rights. That should have got us almost all the way, had it not been for some major logistical challenges. There was usually only one emperor, and he could not be everywhere. As it happened, from the 12th century onwards, he was barely anywhere. The operating radius of the emperors had shrunk to the southern parts of the German lands, so large parts of, for example, the Duchy of Saxony never saw an emperor again for centuries. So who was supposed to do all that mediating and finding of compromises? In the Carolingian Empire, the counts were given the task of adjudicating as representatives of the emperors. But as the role of count had become hereditary, emperors no longer wanted to be held responsible for the decisions of these counts. This left a vacuum that was gradually filled by the dukes and bishops and other territorial lords. And this situation was then formally recognized by Frederick II's privileges for the bishops and princes that were issued in the 1230s. Therein, the emperor granted the imperial princes the jurisdiction over all the people in their territories. So not just the personal servants and vassals, but everybody who lived in their jurisdiction. Based on this privilege, the territorial princes established a system of courts, usually split into a lower jurisdiction that focused on civic disputes and minor crimes, and the Blutgerichtsbarkeit, literally the jurisdiction of the blood, which had the right to condemn people to death and use torture to force confessions. Lower jurisdiction was exercised by the mayor of the village or town, usually in conjunction with jurors chosen amongst the senior members of the community. As the territorial principalities became more vertically integrated, they were divided up into districts, called Ämter, where again a judge and a court were established that were either hearing cases directly or they heard the appeals against the lower courts of the lower level justice. And then there would often be a further appeals process to the princely court or a senior law court in the territory. As for the higher criminal jurisdiction, the Blutgerichtsbarkeit, that was usually exercised by the prince either as a Hofgericht, a princely court where the lord would preside, or as a Landgericht, staffed with professional judges and jurors. Though the territorial courts often had the means to implement their judgments by force, they did maintain the older tradition of preferring settlements over judgments. That was in part down to the complexity and the contradictory nature of the law, but also because such compromises were better at calming down tensions. Rebellions and uprisings were common throughout the 15th, maybe actually 14th, 15th and 16th century, and they could attract the support of jealous neighbors, so princes preferred calm to the strict application of the law. Similar structures were established in the cities, with a lower magistrates' court dealing with civil cases and minor misdemeanors, and a higher court meting out the more severe punishments. These territorial and city courts brought about a major improvement in law and justice, in particular when they were staffed with professional judges who kept records and tried to maintain coherence in the application of the law. But these courts also had some weaknesses. Territorial laws and customs varied considerably from one place to the other. Behaviors and business practices that were perfectly acceptable in one place could be severely sanctioned in another. People who stumbled into these idiosyncrasies might refuse to accept the proposed settlements, leaving the case then open or potentially escalating. There was a major issue for the cities that traded with each other over long distances. Material differences in law and customs could hamper this trade. That is why many cities, in particular those newly founded in the East, copied existing city laws, Stadtrechte, from so-called mother cities. The laws of Magdeburg, Soest, and of course Lübeck were widespread. And to ensure the practical application of these laws remained in sync, complex cases could be brought to the mother city, making, for instance, the Council of the City of Lübeck the appellate court for many Hanse cities. Territories increasingly shifted to the use of Roman law, and then asked universities to opine on complex legal questions, which also brought their practices into some sort of broad alignment, though across the whole system differences remained. Leagues were another coordination mechanism acting as a bridge between different status groups. For instance, the Swabian League maintained its own court system to adjudicate conflict between members, which comprised princes, cities, and imperial knights. The court could even overturn local magistrates' decisions, thereby deepening the integration of their legal frameworks. Therefore, the empire wasn't a lawless free-for-all before 1495, as sometimes been claimed. The inhabitants of cities and territories were bound by rules, adhered to commercial law practices, and were subject to criminal justice, all administered by increasingly professional law courts. But there was a massive gap in the system of the territorial courts. By definition, they had no jurisdiction to adjudicate in conflicts between territories, cities, or imperial knights. The framework under which these conflicts were supposed to be resolved was the so-called Landfrieden, the public peace. When the first Landfrieden was promulgated by Henry IV in 1103, it had already been a step backwards. His father Henry III had forced a great pacification of the empire in 1043 that referred all conflicts to resolution by him and a prohibition of violence. But that has in large parts gone down the Swanee during the regency of Agnes of Poitou and the conflict between Pope and Emperor known as the investiture controversy that followed. The basic concept of a Landfrieden after 1103 was that all the powerful princes would come together and promise to resolve their conflicts through mediation. But crucially, it did not and actually could not ban feuds altogether. Feuds remained allowed, provided the party declared the feud in the proper manner, sought reconciliation first, and did not breach specific rules, like, for instance, not to attack royal highways. After this first Landfrieden of 1103, several more were declared, including ones in 1152, 1158, 1179, 1186, 1235, 1287, 1323, 1383, 1389, 1442, and 1467. Having to say the same thing again and again is clearly not a good sign. The success of these declarations of a public peace depended heavily on the ability of the imperial courts to actually mitigate the conflicts before they descended into feuds. You needed a court that was able to come up with a sensible settlement proposal and do that within a reasonable time frame. And that had not always been the case. Hence these regular renewals. During the interregnum and then the long period when the imperial title moved between the Habsburgs, the Luxembourgs and the Wittelsbachs, emperors simply did not have the time to build up the court infrastructure needed. That meant mediation either did not happen, or was ill thought out, or came too late. And any of these, and then blood was spilled, and once they were going at each other, hammer and tongs, it was 3 times harder to get them back to the negotiation table. And then in the 15th century, things really went properly downhill. Wenceslas the Lazy, Sigismund, and Friedrich III spent most of their time on the eastern edge of the empire, dealing with existential threats in Bohemia and Hungary. Adjudication occasionally stalled completely. And as the 15th century continued, this gaping hole in the legal system gave room to veritable chaos. Princely warfare had also become more intense, with the development of artillery and the growing size of the armies. The imperial knights, whose income from tenants had already shrunk following the Black Death, made up for it by conducting feuds on behalf of paying patrons, in particular of the cities. Even villages resorted to feuds in order to protect their hard-won freedoms. With no mediation process in place, let alone any kind of sanctions for breaking the rules of the feuding, things went seriously out of control. So seriously that even the imperial princes demanded an end to the madness. But on the positive side, the idea that violence was needed to be a legitimate part of any negotiation process had lost credibility by the 15th century. The right to feud against a bad overlord or an unjustified claim from a neighbor was rooted in this concept of vassalage. As mentioned before, a lord had to keep face if he wanted to hold on to the support of his vassals, and that meant he had the right to rebel if disrespected. If you want to check out Otto von Nordheim's speech in episode 31 and 100, you can see the line of argument that justified rebellion. But by the 15th century, that kind of feuding was no longer necessary, because the power of the territorial princes no longer rested on the oaths of their vassals, but on the institutions, the administration, and the military forces they had established. So now they could sustain a negative judgment without losing their land and status. And that is why in 1467 Friedrich III could issue his Landfrieden that banned all feuding outright as a lèse-majesté. That was already a major step forward, though the arrangement still remained time-limited to 10 years, and it lacked an enforcement mechanism since the Reichskammergericht, here tasked with providing mediation and, if necessary, order the execution of the judgments, ceased to operate after 1475. It was only the 1495 Landfrieden that brought this sorry saga to an end. And that document declared that, quote, "From this moment on, no person of whatever rank, status, or condition shall make war on others, or rob, declare feud with, invade, or besiege them, or help anyone else to do so in person or through servitors, or violently occupy any castle, town, market, fortress, village, farmstead, or hamlet, or seize them illegally against another's will, or damage them with fire or in any other way, or assist by word or deed, or in any other way, support or supply any perpetrators of such deeds, or knowingly harbor, house, feed, or give drink, aid, and comfort to such persons." End quote. Bottom line, the Ewige Landfrieden banned private warfare under all and any circumstances, and forever. It established the state's monopoly of violence. And this, once enforced, became another nail in the coffin of the Middle Ages. But as Friedrich III's subjects could tell you, the operative word here is once enforced. Even if everybody would have been happy to outlaw feuds forever, and not everybody did, that still would not have yielded results. Conflicts between the holders of imperial immediacy didn't vanish overnight. The dukes still wanted the cities, the landgrafs, the bishops' lands. The princes still debased currencies, and imperial knights kidnapped merchants. What made the difference was the establishment of two courts, the Reichskammergericht and the Reichshofrat, and the establishment of another coordination mechanism, the Kaiser, the imperial circles. The Reichskammergericht, in its latest incarnation, was established at the Diet of Worms in 1495. Its judges were appointed on October 31st, and it heard its first cases 4 days later. It's a clear sign that, at least occasionally, the empire could move quite swiftly. The reason it did work, and worked for such a long time, came down to a number of institutional choices. As I do not have to explain to our American friends, the composition of a court is almost as important as its remit and procedures. And in the case of the Reichskammergericht, the presiding judge, the Kammerrichter, was appointed by the emperor, whilst the judges who shared the decision-making were proposed by the imperial estates. The imperial estates were asked to submit a list, from which then the incumbent judges would choose the new member of the court. And then the judges, including the presiding judge, would swear allegiance to the court, not to the emperor and not to the imperial estates. Though these appointments did of course have some influence, in practice the Reichskammergericht acted independently from the emperor and the imperial princes. It had its own budget, its own administration and chancery. It was based far away from the Habsburg capital, first as an itinerant court, then from 1527 to 1689 it was based in Speyer, and after that in Wetzlar. This degree of independence set it apart from the territorial courts that aligned much closer to the increasingly absolutist territorial princes. The remit of the Reichskammergericht was to adjudicate disputes between the imperial estates and other holders of imperial immediacy, and banning anyone who broke the public peace for any reason. And beyond this role as the protector of the public peace, it also acted as the final appellate court above the territorial courts. Now, this latter role was, however, somewhat unevenly distributed across the empire, since, for example, the prince-electors, all the Habsburg lands, and then several other senior lords had the jus de non appellando, a privilege that protected their judgments from being reviewed by the Reichskammergericht. Over time, the court was able to chip away at these exemptions before it gained a much wider remit in 1526, which we'll discuss in a minute. Before that, we'll have to talk about the Reichshofrat. So, 2 years after the Reichstag has established the new Reichskammergericht in 1495, Maximilian established another court, the Reichshofrat. The Reichshofrat was very much the court of the emperor. As opposed to the Reichskammergericht, there was the court of the empire. So the judges of the Reichshofrat were appointed by the emperor, and it was based wherever the emperor resided. Its remit was conflicts over rights and obligations of vassals, Lehnsrecht in German. In practice, this involved mostly matters of inheritance. So a typical issue would be the succession to a fief where the incumbent family had died out, or the permission to split a fief between multiple heirs. These two courts did have quite a bit of overlap, since inheritance conflicts could easily tip over into breaches of the public peace. To limit forum shopping, the courts agreed a rule that no case could be brought if it was already pending in front of the other court. One of the Achilles heels of previous Landfrieden arrangements had been the lack of viable enforcement mechanisms. The way the 1495 reforms addressed that was by allowing the Reichskammergericht to demand the Reichstag to then issue an imperial ban to coerce a reluctant party to adhere to its rulings or to cease feuding. However, that process was deemed too slow and complicated, and from 1559 onwards, the emperor was tasked with issuing the ban on behalf of the Reichskammergericht. The Reichshofrat, as the court of the emperor, could issue the imperial ban directly, though there were some limitations to that to prevent abuse. The imperial ban was, however, very sparsely used as a tool. The sanctions associated with it were often simply going too far. It allowed anyone to kill the banned person without repercussions, and his property and fiefs could be confiscated without compensation. The execution of an imperial ban effectively threatened to unsettle the social order, which created a pretty high bar for its application. Therefore, the Reichskammergericht, like the medieval imperial courts before, preferred finding viable compromises rather than bringing down the full force of the law. Where they needed execution, they relied more on imperial circles. These circles had been instituted in 1512 as a means to coordinate on a regional basis. There were initially 6 circles and later 10, comprising the entire empire except for Bohemia, Italy, and Switzerland. The Kaiser became the closest thing the empire developed in terms of administration. They organized the military forces of the empire, they collected the taxes based on the matricule system, they executed imperial and court orders, and maintained the peace in their region. They were headed by a Kreistag, an assembly of the Kreis members. It is here in the Kreistag where the smaller estates of the empire, the cities, the counts, and minor princes were really engaged, rather than in the Reichstag. This is where they passed legislation, coordinated infrastructure projects, and settled their differences. And thanks to the imperial circles, the empire was a lot more coherent in its actions and laws than these maps with 350 tiny statelets suggested. They were so successful that the older leagues, like the Swabian League, that did quite similar things, were ultimately replaced by the imperial circles. Now one would assume that the Reichskammergericht would be more popular for claimants than the Reichshofrat. The former was independent while the latter was under the direct control of the emperor. However, the Reichskammergericht found itself often overwhelmed with cases, making its proceedings slow and protracted. Some of the numbers, in particular Goethe's claim of tens of thousands of open cases, were clearly exaggerated. Sure, there were cases that had been ongoing for a century, but these were often inheritance cases where the purpose was to settle the matter in an amicable way to prevent open hostilities, a scenario where delay can be the prudent choice. Plus, the Reichskammergericht regularly cleared its backlog, suggesting it could not have been all that bad. Also, if necessary, the Reichskammergericht could act very quickly. For instance, commissioners could be sent with injunctions to mobilize the military forces of the Kaiser to prevent breaches of the peace. Nevertheless, the Reichshofrat was a little bit quicker and sometimes more effective, since its enforcement could rely on the full force of the Habsburg Emperor. Moreover, despite its institutional attachment, the Reichshofrat gained a reputation as a defender of smaller imperial vassals against expanding territorial princes. Both Reichskammergericht and Reichshofrat conducted their cases mainly in writing. Lawyers submitted writs and memoranda summarizing their arguments. Before 1495, the courts operated very much in the fashion of a modern-day Anglo-Saxon court, basing its decision only on evidence brought forward by the parties. The Reichskammergericht and the Reichshofrat procedure, however, allowed the courts to task officials with the collection of evidence, for example, taking witness statements. This more inquisitive process spread across the legal system of the empire to the territorial courts, which had some painful unintended consequences. The Imperial Criminal Code of 1532 shifted the responsibility to prove guilt from the accuser to a public prosecutor. Previously, it was the accuser who had to bring evidence for the alleged crime, and if he or she failed to prove the allegation, he or she could face severe financial and even criminal repercussions. But once this task had been taken over by a public prosecutor, it became an awful lot less risky and less expensive to report crimes. So far, so sensible. The more crimes get reported and investigated, the more likely it is that they also get prosecuted. Where that turned into a toxic cocktail was the rise in the allegations of witchcraft. Witchcraft was a crime, and prosecutors were compelled to investigate them if they have been made aware. Torture was a broadly acceptable tool in the investigative process, plus the criminal codes of the time contained scarce protection against arbitrary arrest. So one can imagine what happened. Investigators torture alleged witches, who bring up names who in turn get tortured as well, leading to even more arrests until the whole empire is in the grip of a veritable witch craze. Over the course of the 16th and early 17th century, territorial courts had 22,500 alleged witches executed. Neither the Reichskammergericht nor the Reichshofrat had tools to intervene, since criminal law, the jurisdiction of the blood, had become the exclusive prerogative of the territorial princes. The only grounds for intervention was a breach of procedural rules, which curbed some excesses but failed to prevent the ultimate outcome. A very sad topic we will probably have to get back to at some stage. Now, against this darkness stands a more positive and a more lasting impact of the system of imperial justice. In 1526, the remit of the Reichskammergericht was expanded. It now allowed ordinary citizens to challenge their prince if he or she overstepped their legitimate powers. For instance, unlawful exactions, arbitrary violence, or the violation of traditional rights and protections. This is a fairly rare institutional setup in continental Europe before the 19th century. By submitting themselves to the court's verdict, the princes gave up a big chunk of their autonomy. So, for instance, the Duke of Hohenzollern-Hechingen had to return the hunting guns he had taken off his peasants, and he had to reverse enclosures to increase his hunting grounds. A count found himself imprisoned for 10 years for having forged his subject's signature on loan agreements. Duke Karl Leopold of Mecklenburg was deposed for putting excessive taxes on his subjects and trying to suppress his ducal assembly. So why did the German princes accept that? Now, this decision to expand the remit came in the immediate aftermath of the Peasants' Revolt of 1525, which was the largest uprising in Europe before the French Revolution. It had at that point become clear to the imperial estates, in particular the smaller ones, that they needed a way to ease social tensions. Populations who know that there is a way to seek legal redress for perceived infringements are less likely to risk life, limb, and property on the barricades. It did not work perfectly, and there were several rebellions and uprisings in the 17th and the 18th century, but they were limited in scale and severity compared to similar occurrences in Bohemia and Hungary, where there was no room for redress. Here's what Peter Wilson said about the consequences, quote, "This process had been labeled juridification and involved a fundamental change in the behavior of all social levels. Lords had previously used violence to assert authority and status. Feuding had been criminalized in 1495, and now repression was likely to be condemned in the courts." End quote. The courts provided a platform for princes, burghers, peasants, even the Jewish minority, to hash out their differences based on the understanding that each side could call on certain rights and protections, and that all of that would be supervised by an independent judiciary. Other than in France, common people in the empire did not feel utterly powerless before the institutions of their princes or the emperors. Sure, a court case was hard to mount and ruinously expensive, but it was possible, and it had a chance of success. And that in part explains the lack of enthusiasm for the French Revolution amongst the broader population in Germany. Like in Britain, Germans were quickly turned off by the excesses of the Jacobin rule, and they simply did not see themselves being as oppressed by their governments as the French. That did then change once the empire and its legal safeguards against princely overreach had gone, but it was still there in 1789. The other lasting impact was that calling a court for help became the Germans' reflexive reaction to injustice. Germans, or at least Germans of my generation, see their country first and foremost as a Rechtsstaat, a state under the law. Let me end with a quote that I found in Peter Wilson by a Habsburg official, Joseph Haas, bemoaning the dissolution of the Reichskammergericht and the Reichshofrat in 1806. Quote, "The judicial power, which was until now the shining jewel of our constitution. Two imperial courts, whose councillors were appointed with great care and were free of external influence, competed with each other in the impartial administration of justice, and gave even the lowest subject rights against the most powerful prince. Now that these are dissolved," he goes on to say, "there is no doubt that canals will be dug, roads laid, avenues and parks, theatres and pools created, cities illuminated, and we will shine and starve. The only robbers threatening the subject's property will be the tax collector, the French and German soldiers." End quote. This brings our mini-series about the Imperial Reform of 1495 to its conclusion. Next week I'll be away in Naples because, well, I cannot bear the incessant rain here in London any longer. But I leave you a particular present. I did an interview with Professor Duncan Hardy, who I have mentioned several times before and who is a true expert in the empire of the 15th and the 16th century. I'm sure you'll find that as enlightening as I did. And in the meantime, spare a thought for your hard-toiling podcaster who has no Reichskammergericht to call upon for fair wages, but lives in hope of the generosity of his fellow history nerds. And if you want to be part of that exclusive club that luxuriates in the soft glow of your fellow listeners' gratitude, go to historyofthegermans.com/support and click on any one of the options.